Good morning, everybody. Thank you to everyone who's joined us this morning on our HR Hotline Live. We're going to talk today about COVID-19 and its impact on the workplace in Connecticut. Please keep in mind that for this particular hotline, we are only going to talk about COVID-19. And so we'll take questions about the vaccine, about sick employees, about employees who don't want to or can't come back to work, reporting requirements, anything related to COVID-19. We will do our very best to answer as many of your questions as we can in the next hour. Please keep in mind that if you have questions to submit, please do that through the Q&A function on the bottom of your screen and not the chat function. We're not going to be checking the chat. And so if you have a question, please submit it through the Q&A. So I'm Diane Mokriski. I'm HR Counsel here at CBIA. And I'm here with Vincent Farisello, who's a partner at Carmody and Torrance and whose practice focuses on labor and employment. So he's an expert in this field. Good morning, Vincent.
Good morning, Diane. How are you?
I'm good. How are you? So the first thing that I'd like to touch on this morning is an issue that I think will probably answer a lot of your questions out there this morning, and that has to do with the new and improved rollout of the vaccine. I'm sure many of you have heard that Governor Lamont made an announcement earlier this week on Monday that the vaccine is going to be rolled out quite differently than what the state had originally anticipated. And so a lot of you are probably familiar with the concept of the essential frontline worker. And over the past several weeks and months, we've been getting lots and lots of questions about that concept, the frontline essential worker. And it's actually been, I think a lot of you would agree, a pretty complicated and confusing issue. There were 13 different categories of frontline essential workers, and we had lots and lots of questions about how to tell if you fell into one of those 13 categories, and what do you do if you have an employee who's working part-time, and how much interaction do you actually have to have with your customers to be considered frontline? And it became pretty clear that there were a lot more questions than answers, and that issue of the frontline essential worker was going to really slow down the vaccination process, which is the opposite, obviously, of what we all want. We want to try and vaccinate as many workers as we can in a short amount of time as we can. And so one thing that became clear is that over the course of this pandemic in Connecticut, 96% of the fatalities in our state have been of people who were age 55 and older. And so with this new rollout of the vaccine, beginning March 1st, Monday next week, if you are age 55 or older, or you work in the education field in Connecticut, you will be eligible to make an appointment for the vaccine. And that's a big change. Essential frontline worker is no longer an issue. It's almost entirely age-based. And I say almost entirely age-based because then there's also that issue of being in the education field in Connecticut. And so on that issue, on the education field in Connecticut, it's not just teachers. The idea is that it's for anyone who either interacts with students or who works in a school building. So that could be custodians or food service workers, bus drivers, paraprofessionals, and teachers, childcare workers. And so anyone, regardless of age, beginning next week, if you work in the education field in Connecticut, you're eligible to register for the vaccine. And also, if you're 55 and up, beginning next week, you can register for the vaccine. So the biggest change, I think, for a lot of you out there as employers is that it's no longer your job to get your employees registered. And I think that's probably a bit of a weight off your shoulders. For all of you employer coordinators who have been diligently waiting by your computer, waiting for that famous email from VANS telling you you can upload your employee roster, that email is not going to come because you don't have to worry about that anymore. It is not the employer's job to upload a roster. and it's not the employer's job to get the employees vaccinated or registered. Right now, it's the employer's job to run your business. Okay, so we have a much more streamlined process now. And the idea is that for each age group, that will hopefully take only about 3 weeks. And so if we start with 55 and up on March 1st, by March 22nd, we'll be able to go to 45 and up. And by the middle of April, 35 and up. And so with each age group, the amount of people will be increased, and it's up to the employees to get that done. And it'll be easy for them to figure out if they're eligible because it's based on age and whether they work in the education field. So on that note, I'd like to just go to the first question that came in, and it has to do with the rollout. And the question is, this person has an employee who lives in Rhode Island but works in Connecticut. The person's in his 20s and he works in the manufacturing field, but he has asthma. So does he meet that requirement that would allow him to be vaccinated on March 1st? And the answer is no, because comorbidities and health issues are no longer an issue when we're determining whether you're eligible to get a vaccination. And so now when you're determining whether you're eligible, it's actually much simpler. It's really just a two-step process. Step one, do you live or work in Connecticut? If yes, you move on to step two. Are you in the right age group, or do you work in the education field in Connecticut? If you do, you're eligible to sign up for a vaccine in Connecticut. And so for this guy who lives in Rhode Island but works in Connecticut, he met step one. That's good. He works in Connecticut, but he's not in the right age group, and he doesn't work in the education field here. And so he's not eligible, and he needs to wait for his age group or get vaccinated in his home state. Okay, and so Vincent, I think I'll throw this next question to you. It has to do with a very common question we've gotten a lot lately, and that is, should we require our employees to get the vaccine? And can we require that they get the vaccine?
Thanks, Diane. Yeah, it's a question that we have gotten a lot over the last few weeks and months. And I kind of look at it in two different ways. One, there's sort of a legal analysis there, which I'll go through. And then I think there's also a practical analysis. And so what some folks have probably heard is that in December, the EEOC issued informal guidance stating that employers can implement and mandate mandatory vaccination policies, provided that one, employers reasonably accommodate employees who may not be able to take the vaccine due to the employee's disability. And two, employers accommodate employees who are against vaccinations due to a sincerely held religious belief. So, like I said, there's kind of a two-step thing here. Let's start with the legal analysis. I'll start with the proposition that the informal guidance, it's not a law. It's just that, it's informal guidance. It doesn't carry the force of law, and it's not even considered an agency regulation. Regulations actually have to go through a formal rulemaking process. So, you know, while it's good that it's out there, we know the EEOC's position on it, an employer who relies on that guidance to mandate isn't necessarily shielded, however, against any liability and could theoretically still be sued in court. The second part of the analysis are those caveats that I mentioned, the exceptions, or considering exceptions for employees with disabilities who can't get the vaccine, or those with sincerely held religious beliefs. The employer in that situation can also think about, okay, if I provide that accommodation, am I, however, allowing, is there going to be a direct threat to other employees in the workplace? If everyone else is, if most folks are vaccinated but some aren't, are they going to pose a direct threat? That's a specific analysis to do under ADA law that, you know, the employer could consider, you know, what that risk is, the nature and severity of it, how likely it is to occur. But it can be mitigated through other measures. Like, you can still accommodate someone, I think, by not forcing them to take the vaccine, and still mitigate the risk of spreading the disease by providing other safeguards like increased social distancing, other types of accommodations. The other thing I would point out on the legal front is while the guidance is persuasive, it came from the feds, it's not necessarily binding in Connecticut. It's true that Connecticut generally does follow federal law on disability and discrimination type issues, but this guidance isn't necessarily binding on the CHRO, the state's version of the Human Rights Commission. And so it's possible, theoretically, that the CHRO could conclude that our Fair Employment Practices Act, which is a state statute separate from the ADA, provides some kind of greater protection than what the ADA does. And then there's also the possibility of other types of legal claims, including, for example, I'm trying to put my plaintiff's hat on, are you kind of invading someone's privacy by trying to dictate those kind of health decisions for them? So that's the legal analysis. Bottom line is, yes, EEOC says you can do it, subject to the caveats that I've just mentioned. Let's talk about some of the practical considerations too. One, you do have to recognize these are new vaccines. Unlike the flu vaccine, they haven't been around for decades. And so, there is theoretically some risk if you require employees to take the vaccine and then they become sick as a result of it. And that could take a form of a possible workers' comp type claim, by forcing someone to do it, because you kind of bring it into that related to the workplace. The other couple practical considerations are, it's not even perfectly clear at this point whether the vaccine actually reduces, blocks transmission. Is it just protecting the person who took the vaccine? I think it's an open question still about whether it actually blocks transmission of it. There could be the morale issue, because I've seen statistics that say 20 to 40% of people do not want to get the vaccine, don't trust it. Whether that's right or wrong, not for us to decide. But what will you do? Do you have to come up with a game plan for if you get a significant part of your population that says, I'm just not doing it?
Right.
Well, then what? Puts you in a funny spot. And so I think when you put all of that together, the typical advice we've been giving is, except in certain circumstances, for example, healthcare facilities, childcare facilities, my advice has been to strongly encourage folks to get the vaccine as opposed to a blanket mandate of it. And I think, what goes hand in hand with that is an education campaign, providing employees with reliable information from the CDC, from the state, about the safety and the efficacy of the vaccine. And I think the more folks get educated about it, I think there's a better likelihood they'll be willing to do it and take your strong recommendation as an employer. And then the other thing you can do is make it easy for folks to get the vaccine. I know you talked about we're not in the business as employers anymore of registering people and doing that. And I think for my law firm, that's and other clients that I have, that's good news. I don't think a lot of people want to be in that business, but you can be flexible with work schedules to allow people time to go get the vaccine. You can help make it easier for them to do that. And then, of course, in the meantime, continue following the state's guidelines on social distancing and the reopened Connecticut guidelines. Continue following CDC stuff. And I think doing those things goes a long way as well.
Okay. All right. So a related issue, you mentioned reasonable accommodations, and that in some cases, that would be a scenario where you wouldn't be able to require someone to get a vaccine if they needed a reasonable accommodation. And that concept also comes up, I think, when an employer has an employee who just doesn't want to come in person. They've been working remotely for the past 9 months and they feel vulnerable and they just don't want to come in. And so can you explain a little bit, what should an employer do? What are the actual steps that they should take if an employee says, I can't come in?
This is another one. I think this is actually the question that we have gotten the most since last March. And so I try to deal with this in a systematic and analytical approach, especially because I have seen many of my clients often have their own suspicions about why an employee is actually requesting to stay out or to keep working from home. And so sometimes I see that those suspicions can creep in and influence how the employer is actually analyzing the situation. And I think it's broader than just the disability stuff. So I'm going to take a step back and kind of attack it in a holistic kind of approach. And this will give insight into when I get that call from the client, here's the analytical approach that we do. First, I start with the question about the necessity to have someone return to the office in the first place. Just remember, I'm not, we got to keep in mind that the state and CDC are still recommending continuing social distancing, including allowing employees to work from home to the extent that's possible. I am not saying that an employer can't or should not return people to the office. I'm just saying that I think the employer should, as it's good business to be able to articulate, be prepared to articulate the business reason for why we're having everybody come back in. And that could be because our industry is allowed to be reopened, or our industry is allowed expanded capacity, or frankly, while folks were working from home, there was a significant loss of productivity. I mean, those are all very legitimate reasons to want to have people come back to work. So start with that. Next, what is it that the person's requesting? Are they currently not working? Are they on furlough? Are they collecting unemployment? And they simply want to continue doing that? If so, you should explain to them that you have work and you need them to come back. And if they flat out refuse, you can consider letting the Merit Rating Unit know from the Connecticut Department of Labor if you've got work for someone and they're simply refusing to come in and don't want to do it. But the more common scenario is the employee who's been working from home for the last several months and wants to continue doing so. So in that case, you need to inquire about the reason that they're requesting to continue working from home. And I'm gonna, this is what I meant when I said I'll attack this holistically. It's more than just disability stuff. Is it a child care issue? If the reason they want to continue working from home is a purely child care issue, well, aside from FFCRA stuff or other possible FMLA type situations, FFCRA, and we may talk about this later, it's currently voluntary. There's no legal obligation to accommodate someone simply to provide childcare to allow them working from home. So there may be no obligation to do it in that situation. Does the person simply have a generalized fear of COVID? They've been watching the news, they know what's going on out there, and they're just generally fearful. Again, no general legal obligation to accommodate that kind of generalized fear. Could be a little different analysis if the employee can identify tangible health or safety hazards that are specific to the employer. They've identified maybe the employer's not following social distancing, not following the state guidelines. Well, they may, that employee may have some protection, but short of that, if it's just a generalized fear, no real obligation to accommodate that kind of request to work from home. Another very common one is, I want to continue working from home because I need to avoid exposing a family member at home, my husband, my wife, my parent who lives with me, or my child. They're a high-risk individual, and I don't want to expose them. And so, the analysis there is, although the ADA prohibits discrimination against someone based on their association with someone who has a disability, that protection is limited to prohibiting disparate treatment or harassing that person who's related to someone with a disability. The ADA doesn't require accommodating an employee who does not have a disability themselves based on the disability-related needs of a family member. So in other words, an employee without a disability isn't entitled under ADA to work from home as an accommodation simply to protect a family member. And it's kind of a similar analysis with if someone is saying, I want to continue working from home because I'm over 65 and I heard that that makes me in and of itself high risk. You know, in that case, what you're really talking about is a law called the Age Discrimination in Employment Act, and that, you know, that like the last situation I just said, you know, it does prohibit discrimination against somebody based on their age, but there's no obligation under that law to provide an accommodation to continue working from home. But if that person is over 65, has a medical condition that requires them to work from home, and this is what I think you're really getting at, and this is the most common scenario, someone's requesting to continue working from home based on their own medical condition or disability. Well, in that case, granting continued work from home or maybe even an unpaid leave of absence, it could be a reasonable accommodation under the ADA. And in that case, what the employer should do is engage in the interactive process with the employee. If the condition or disability isn't obvious or isn't known to the employer can and should ask questions or request medical documentation to determine whether the disability necessitates an accommodation, necessitates the accommodation requested, or perhaps another accommodation. And you know, questions an employer can ask under the law include things like, how does this disability create a limitation? How will this requested accommodation address that limitation? How will this proposed accommodation enable you to continue performing the essential functions of the position? But it doesn't stop there. Depending on the answers to those questions, the documentation that's provided, engaging in the interactive process means that the employer can propose alternatives too. We can explore other options. Maybe it's modifying a work schedule, you know, working on a staggered shift, maybe modifying a shift assignment. Maybe it's a temporary relocation of a workstation. Maybe it's a temporary restructuring of some marginal, not essential duties of, essential functions of the job. But you can explore and have a give and take with the employee. If the work from home thing is going to be a problem for you, you can try to explore alternatives. If you can't come to agreement, if you can't find some other alternatives, and the employee you're back to that work from home on the table, that's not an absolute thing that an employer absolutely must do. If that would create an undue hardship on the company, they may not have to provide that accommodation. And what does undue hardship mean? It means whether it would impose on the employer a significant difficulty in operations or significant expense. Honestly, it's a tough burden to meet, especially for larger employers. And the fact that you as an employer may have been allowing work from home for so many months kind of has there's a double-edged sword to that, right? The EEOC and its guidance says, hey, the fact that you were doing that when you were mandated to be closed down or whatever doesn't create an absolute right that you must provide it in all cases going forward. However, if you did provide it and it was working okay, it's hard to then claim that it would create an undue hardship. So if you're going to look at the past history as reason why you can't do it, you should be able to identify the issues that occurred while that was happening, why it didn't work, whether it be significant loss of productivity, inability to do essential functions of the job that you were able to temporarily excuse, but can't do indefinitely.
Okay. All right, let's move to the next question, and that has to do with OSHA. I think I'll take that one. We have someone who's wondering what their reporting obligations are to OSHA if they have an employee who tests positive. So when it comes to OSHA, there's actually two verbs to keep in mind, right? There's recording, and then there's reporting. And they're two different things. And so OSHA has determined that COVID-19 is a recordable illness, in certain circumstances. And so first of all, let's make sure that everyone knows that if you have 10 or fewer employees, or if you're in a low risk business, then you have no obligation to record in the first place. So we're talking about larger employers. And then the duty to record, let's say you have an employee who tests positive, the duty to record only applies if you meet three requirements. One is that the person is actually confirmed positive, not just that you presume he's positive because of his symptoms or because his family members were positive. He has to have a confirmed positive report. The second is that it has to be work-related. And it's probably going to be pretty rare that someone can actually prove that your worker contracted COVID at work, unless there's something really obvious. Like, let's say you have a cluster of 3 or 4 employees and they all contracted COVID within the few-day period and they work really closely together, then it would probably be reasonable to assume that your person contracted COVID at work. But unless you have a situation like that, simply because you have a worker who tests positive, that doesn't necessarily mean that they got it at work. And so that doesn't make it a recordable event. And then the third issue, not only is, in addition to having it be confirmed positive and it being work-related, is that it has to meet that general requirement for recordings in general, which is just that the person needed days away from work or they needed significant medical treatment. And so if you meet all 3 of those, you have a duty to record it. Just keep track of it in your OSHA log. The duty to report it to OSHA only comes up if the employee is hospitalized or the employee dies. And in that situation, you only report it if the person is hospitalized within 24 hours of contracting it at work, or the person dies within 30 days of contracting it at work. And so if either of those 2 things happen, then you report it to OSHA. All right, let's move on to a question about quarantining, Vincent. If a person at work is exposed, let's say one person at work notifies their boss that they're positive, and he actually was coming within 6 feet of some of his colleagues, and so some other people at work were exposed. What should the employer do for both the sick employee and the exposed employees?
Sure. So, obviously the first thing to do in that case is have the employee who tested positive stay home, not come back into the workplace. It should be obvious, but just make sure we put it out there. And they should, and that employee should not return to work until they have met the CDC's criteria to discontinue home isolation. And what those rules are, I'm presuming that the employee in your situation, I won't presume, I'll say, let's say that they have COVID and they were symptomatic. They should then stay home. CDC recommendations is they should stay home until 10 days have passed since the symptoms first appeared, and that 24 hours have elapsed without fever, without use of a fever-reducing medicine, and any other symptoms they have also improved. So they should stay out for that period of time. If they tested positive but were asymptomatic, they should nevertheless stay out until at least 10 days have passed since the date that they gave the sample that resulted in the positive test. Of course, if at any point in time they become symptomatic, then they should remain home, subject to those other rules I said, 10 days without, since the symptoms first appeared, and then 24 hours without the fever reducer. So we've dealt with that employee. The next thing you should do is, and I'll get to the exposed employees as well, but just in terms of process, next thing you should do is consider closing off any areas that sick employee had been using for prolonged periods. In most cases, it does not mean that you need to shut down your entire facility, but it could mean closing down certain rooms, offices, workspaces, departments, etc., and you should keep them closed until you have a chance to clean and sanitize. Then, of course, you should inform the other employees of the possible exposure, but be careful not to name the employee who tested positive, unless that person gives you consent to release their name. And you might also, not just fellow employees, if the sick employee had contact with some of your customers or vendors, you may want to inform them of that possible exposure. The next step, and this is where I think you were going, is determine which employees may have been actually exposed, who had this close contact. And you made the reference to, what does that mean, being within 6 feet of someone for 15 minutes or more. You have to identify who may have had that close contact in the workplace. That starts with talking to the person who's sick in the first place, talking to them about who they may have had that kind of close contact with. And this might, you might use some of the contact tracing protocols that you already have in place to try to determine who was where and when. And so the exposure, so you have that. So I think the question then becomes, you identify some folks who have been exposed. How long should they quarantine? Do they have to quarantine? And so if the person who was exposed is symptomatic, they develop symptoms, then they should quarantine until they've met the criteria to end home isolation, which we've already gone through. If the person who had contact, who's been exposed, is not symptomatic, does not have symptoms, then the conventional wisdom had been they should nevertheless quarantine for 14 days. But there is the option to reduce that now in Connecticut. Connecticut has come on board. They've recognized, along with CDC, that that there's a bit of a balancing act, right? The safety of a 14-day quarantine versus people not necessarily following it or coming forward or being honest to avoid that because it's so burdensome. And so as a result, someone who's had close contact could stop quarantine, end quarantine after 10 days of that exposure if they do not get a test. And in the alternative, they can end the quarantine after day 7 if they received a negative test, but that negative test occurred on day 5 or later.
Okay.
So that's how long they should stay out. Aside from that close contact, if we're just talking general, we were in the workplace, but not necessarily that within 6 feet, 15 minutes or more, then you don't have that close contact, and it's no different than just community-wide exposure. And so there is no real obligation of quarantine there.
Okay, so the next question has to do with the liability that an employer may face when they do everything right, but the employees don't necessarily do everything right. And I'll read the question, but I just want to point out before you answer it, Vincent, maybe a misunderstanding within the question. So the question is, if an employee refuses vaccination and we as an employer provide proper PPE to protect other employees, but the refusing employee is not practicing COVID distancing outside of work and gets COVID and then infects another employee, and then in the worst case scenario, the employee who followed all the guidelines dies, can that employer be sued? And just before I give you that question, Vincent, I just want to point out that getting the vaccine, we don't know for sure. It doesn't necessarily mean that you can't give it to others, right? And so simply the part of the question that says it has to do with this employee who's refusing to get a vaccine, that's not necessarily relevant, because just because you've gotten a vaccine, that doesn't mean you can't spread it to others. So the question I want to give you, Vincent, is what kind of risk does an employer face if they're following all the rules, but their employees go out at night, they don't follow social distancing measures, and then they come into work and they infect someone, and then that person gets really sick?
I think in a situation like the one that was just described, the employer in that case was acting reasonably, was doing the things that were necessary, that would reasonably be expected to happen. So I don't think there would be a significant risk of liability there. At the end of the day, we can't police what people do outside of work.
Right.
But the other part of this is, something you mentioned earlier when you were talking about OSHA. How do you know that the person actually got it at work? If they are somehow able to prove or it is very likely it's apparent that they got it from work, it's a similar analysis under the workers' comp law that you mentioned when you were talking about OSHA. And the other thing I would point out is if the person got it and died from it and can show, and it's likely they got it at work, it might have been arising out of or in the course of their employment, the employer, even in the worst case scenario, would probably have some coverage or cover through the workers' comp process. And that's important because work-related injuries, illnesses, occupational illnesses, the exclusive remedy for employees who suffer those work-related injuries or occupational illnesses is the workers' comp process, and for which most of us here have coverage.
Okay. All right, the next question has to do with the FFCRA. The question is, now that it's expired and it's voluntary, are employers paying employees to be out for the 10 to 14 days, or do they use PTO, and do they take it unpaid? Can they file unemployment? So I'll touch on that. This writer is correct. The FFCRA did expire on December 31st. And so through the end of March, it's voluntary. And we are finding that, it's mixed. There are a lot of employers who are still voluntarily providing paid time off, because the risk of doing it otherwise is that the employee comes to work and they may have COVID, and you don't want that. You'd rather that they stay home, right? And so you can either, through the end of March, pay them paid sick time if they haven't exceeded their allotment under the FFCRA. You could also allow them to use their PTO, or if they don't have any accrued PTO, to answer your question about unemployment, if they end up staying home and they don't have any PTO left, they can file for unemployment. Okay. So let's move to another question. This is about insurance, Vincent. What do you think about this? If our employees do not want to get vaccinated, will we have issues with insurance, such as yearly renewals being denied because they have unvaccinated employees?
I don't think that would. I don't think that would happen. I don't think they'll have issues getting coverage. I think if anything, if you wind up having significant, if your medical loss ratios go way out of whack because of a lot of people getting sick, that could certainly impact your renewal rates. But I've not heard of anyone being, I've just not seen this come up or heard it occur. And so I don't think that it's a significant risk.
Okay, yeah, because the vaccine is not required, right? It's not required. The state isn't requiring it, and the employers very likely aren't requiring it. So there would be no basis for, this is all new, right? We'll see what happens, but I agree. I think it's unlikely that an insurance carrier would be able to impact your insurance simply because you have unvaccinated employees. Okay, so the next question is this: in parts of our process, we are not able to maintain a 6-foot distance for entire shifts. And so we have employees in masks as well as with plastic face shields, as it's not feasible to use plexiglass. Due to the mask and the shield, if we had a positive case, would those employees who work in that part of the process be deemed to be in close contact?
It's a really tough one. And the CDC guidance has kind of vacillated a little bit over time on this. At points, it did used to, one thing that's been consistent is that the 6 feet 15-minute thing. It's not really a black and white. It's not a bright line rule. It's kind of, you know, there did used to be in a prior version of the guidance, it did take into account, you know, is one wearing a mask, is both wearing a mask, etc. My recollection the last time I looked at the guidance was, though the longer you're in contact, even if you do have the mask and the face shield, the longer you're in that contact, the higher likelihood that you've been exposed. And so, you know, I don't think that just the fact that folks were wearing masks and face shields just means that that you're excused from, or that they weren't exposed or didn't have that close contact, especially if, you know, the longer you go in excess of 15 minutes
right
in proximity with that person, the longer that is, the more likely the person was exposed. So
yeah,
I think I would say that.
Do you agree it has a little bit to do with, I mean, you've got this risk assessment that you have to make. And so you've got people in the masks and shields, but they're working really closely together. They could have spread it to each other. I mean, do you want to take that risk? What's the upside? What's the downside, right? And so I don't know that there's a definite black line rule there, but I think that there is a risk that if they were working closely together, especially if the person, let's say the person who ends up having COVID has really severe symptoms and is coughing and, you know, sneezing, and I think that makes it more likely that even with a mask, they could spread it to someone close by.
Yeah, absolutely.
Okay, we had a question that it looks like maybe it was answered in writing. I'll just mention it really briefly because it's a very simple answer, and that is, do employers still get the tax credit if they use the FFCRA before March 31st? The answer is yes. And so I've got a question from an aerospace manufacturing company.
Can I jump in real quick on that, on the last one? Diane, one thing I had seen, the IRS, this is with regard to the FFCRA stuff, in late January, they updated their FAQs in light of the voluntary extension. And they've said that in this updated FAQ, the tax credits are available for paid leave between that period of time only to the extent that leave would have satisfied the requirements of EPSLA and expanded FMLA. So deviating from what the requirements are in any way could impact the tax credit. And why I bring that up is because some folks have said, well, can't we just do the EPSL part of it, but not the EFMLA part of it? And so I think this FAQ has shed some light on that. So if you're going to volunteer to do it, you got to be prepared. I think the upshot is, if you're going to volunteer to do it, you got to be all in.
Okay, so you're saying if an employer voluntarily extends through the end of March the ability to take paid sick leave because they have COVID, that they should also extend the family and medical leave portion of that.
Yeah, that's the way I took that to mean, that FAQ.
Okay. So we have an attendee who is saying that one of their suppliers is saying that they will not do any further business with them unless all their employees are vaccinated. That's actually kind of surprising to me. I think that company is likely to really limit themselves on who they can do business with. But this person is saying that that's what they're being told. So what can they do to minimize the loss of supplier contracts?
Well, I think I would start with having a heart-to-heart with the supplier, with the customer and the supplier in the first place. But they've really put that employer between a rock and a hard place there. I mean, I go back to what we were talking about in the beginning. Can you then turn around and mandate your employees? Yeah, we talked about that. The EEOC suggests that you can, subject to those, to the legal analysis risk factors I identified, i.e. doesn't have the force of law, may not necessarily be recognized by Connecticut law, but you can still mandate. But then you may have the situation with the folks who can't get it because of the disability again, or because of the sincerely held religious beliefs. And you know, subject, you know, short of the supplier, you know, giving some flexibility there may not be much you can do. You know, you may wind up having to, if you simply cannot, because that might create an undue hardship on the company because of the loss of the contract, and therefore, I guess you could argue that you can't accommodate the disabled or the religious, the sincerely held religious beliefs, you know, those two folks who need that accommodation. If you can't provide that because it would cause an undue hardship, because you might lose this contract, you know, what you might, you know, you should be, EOC says you shouldn't terminate someone on that basis. So you may be looking at providing them some temporary unpaid leave while the situation resolves itself. But you really are stuck between a rock and a hard place there. And so it's going to require some crafty negotiation.
Yeah, I think that just practically speaking, the supplier who has that requirement is going to find that their options are pretty limited, because I don't know, I guess we'll see, but I think it's going to be unlikely that they'll be able to find companies that have a 100% of their employees vaccinated. So we'll see. How about a question on unemployment, Vincent? Do you know if an employee is laid off for a COVID-related reason, or lots of employees laid off for COVID-related reasons, does the employer have to be prepared for a much higher experience rating? And can you explain just a little bit about what an experience rating is?
Sure. So most, remember that most employers, especially for-profit employers, pay into the unemployment comp system through a tax that varies based on the number of claims that the employer has experienced. That's called the experience rating. And so depending on an employer's experience rating, that tax rate is set anywhere between 1.9%, I believe, on the low end, to 6.8%, I think, on the high end. And that tax rate is just payable on the first $15,000 of earnings. So typically, anytime an employee is granted unemployment benefits, that impacts the employer's experience rating, and therefore would theoretically increase their tax rate. Governor Lamont, in one of the executive orders, I believe it was last April, but in any event, it was 7W, I believe, issued an executive order that says, if the labor commissioner or his or her designee determines that a claim is granted based on a COVID-related reason, then the employer's experience rating will not be impacted by that. So the employer will not get impacted by COVID-related unemployment comp claims. And that executive order has been extended a couple times, most recently last month, so it's still in place. And so the answer is no, it will not, for now, impact an employer's experience rating.
Okay. So we talked a little bit about whether employers can mandate vaccines and whether they can mandate test results. One question is, should you keep track of your employees who have been vaccinated? You can tell me what you think. I think my general reaction to that is an employer can keep track of that. An employer can ask employees for information about that, can ask for confirmation that they've been vaccinated. And I think that that will be helpful for employers to know. If they know, hey, I've got 75% of my workforce is vaccinated, that may make it safer for everyone to come back in person. That will also, I think, impact who needs to quarantine under certain circumstances based on who's vaccinated. Do you have any thoughts on that? Are there any risks involved with keeping track or anything like that?
I think that I would have started exactly the way you did, that you can ask. There's probably some good reasons to ask. I would simply, through asking, try to avoid getting into, if the answer is no,
right.
You know, you may want to avoid getting into too much detail, especially, you know, EEOC says asking if someone got the vaccine is in and of itself not a disability related inquiry. So you're allowed to ask it. But if the answer is no, because I have XYZ disability, or, you know, you're asking, well, why didn't you get it? And, oh, what's your disability? Then you're wading into a line of questioning that you should be avoiding. The other thing I would say is if you do keep track of it, do keep those records, you should keep those records separate from regular personnel files, and you should make sure that you take steps to keep those records confidential and protected. Under, you know, I would be worried, you know, you have obligations to do that under both ADA and also Personnel Files Act in Connecticut.
Okay. Okay, this is a kind of a common question that I get, and is it, and the question is, can I require my employees to stay home if they're either positive or they've been exposed? Let's say the employees on their own don't feel like it's necessary. If I know that they're not going to get paid time off, can I nevertheless require them to stay home even though they won't get paid?
Yes.
Yes, the answer. That's the short answer.
Yeah, that's the short answer. I always be careful. Listen, you always have to be careful when you're talking, you know, about exempt employees, because the, you know, exempt employees, to be exempt in the first place, are subject to the salary basis test, which means that they make the same amount of money week in and week out, regardless of the quality or quantity of the work that they do, regardless of the number of hours that they work. And there's some exceptions to that, pardon me. There's some exceptions to that where an employer can take some deductions, and, you know, so, you know, we can get into some of that, but I think the long and short of it is, yes, an employer can do that. There could be some unemployment consequences involved if someone's not working through no fault of their own and they're ready, willing, and able to work, or if they can't work because of a COVID-related reason under some of the federal unemployment CARES Act stuff that's been extended. They'll likely be eligible for unemployment in that situation. So that could have an impact on the employer. And then again, if we're talking about exempt employees, if they've only missed a portion of a day, you know, the employer shouldn't take any deduction for that. You know, and, you know, it gets a little bit, you know, into the weeds on the reasons one could take deductions for full days of missed work for exempt employees. But if someone was dealing with that, I would say it's worth just double checking those 7 permissible deductions before doing them.
So now if an employee is asked to stay home because they've tested positive, I wonder though if their unemployment claim would be denied because they really wouldn't be available for work. I don't think, at least they shouldn't be available for work.
Right. In the ordinary, in the ordinary course, to be eligible, you have to be able and available for work. And if you're required to be quarantining, you don't necessarily meet that. I don't recall off the top of my head, but I do know that one of the, I get lost in the acronyms of PUA, PEUC, TUC. My recollection is though that one of them did allow for some relief to that for certain COVID related absences. I don't remember if being COVID positive was one of those, but certain inability to work due to COVID, you know, there had been some relief from that.
Yes, I think that's right. All right, so we've got a question from an employer. This is somewhat related to the rollout, and the question is, they were thinking that they were going to have all their employees vaccinated together via a clinic. That is now pretty much a thing of the past because the vaccines are not employer organized anymore. And so if you were thinking in kind of a theoretical sense that when it was time, when your frontline essential workers were ready, that you were going to have someone do a clinic for all your employers. That is not likely to happen now, until, at least not until later in the spring. Once we have a greater range of ages that are eligible to be vaccinated, it's possible that we'll have more clinics. But for now, keep in mind that the duty to, or the responsibility to get yourself vaccinated, it falls on the employee now, not on the employer. And so it wouldn't really make sense to have a clinic for all your employees aged 55 and up, and then 3 weeks later do a clinic for all your employees who are 45 and up. That doesn't really make sense anymore.
Diane, have you heard of this? I was doing a presentation for an industry group at some point, and one of the employees, this is back when employers were scheduling these and doing
Yeah.
Someone had mentioned, and I've never had a chance to look into it, but one of them mentioned that if you go and sponsor, coordinate a clinic at your workplace, that the state would require you to have it be open to others. Is that true? Have you heard anything like that?
I don't know the answer to that, but now that won't be a thing.
It's a moot point now, right?
Yeah.
Right.
Yeah. I will just mention, when it comes to, we've been focusing on the fact that it's the employees now who get themselves vaccinated. When it comes to people who work in the education field, there is a little bit of a wrinkle there, not a wrinkle, but it's not going to be entirely up to the teachers and childcare workers to just go and find a vaccine. What will happen is your local town or your Board of Ed or some regional entity will contact you, and there will be a clinic specifically for the teachers in your area. So if you're a teacher or a childcare worker and you realize that you're eligible, you don't need to go out and see if you can find a vaccine somewhere. And the reason for that is the state has actually set aside a specific number of vaccines that are just for people who work in the education field, separate from the vaccines that have been set aside for people who are age 55 and up. And so not only are you not required to go find a vaccine if you're a teacher, you shouldn't go try and find a vaccine. That will be your school district will make sure that you get your vaccine. And also just keep in mind, remember, we're still dealing with, even with, if we limit it to 55 and up and teachers, we're still dealing with hundreds of thousands of people. And so you may not get your appointment in the first week of March, but the goal is for every person in the education field in Connecticut to get their first shot in the month of March. So that'll be our goal. So this may be our last question. I think we only have a couple, oh, and that question just disappeared. Okay. So we have a question, Vincent. So the 10 to 14 days may not be covered by unemployment if they're needing to stay home. Okay, I think we actually covered that.
Yeah.
All right, so I think if there's anything else, Vincent, that you wanted to emphasize today regarding either quarantining or anything on those lines, I think we've answered all the questions.
Yeah, I think I would just reiterate to folks that continue, don't drop your guard for now. I know there's been some positive news over the last few weeks and month about the positivity rate. It spiked a little bit yesterday, but do continue following the state's rules on, the reopen rules, continue monitoring the CDC guidance, continue doing those things so that this positive trend we're on can continue. And yes, I live and breathe this, and I've been doing it for almost a year now, but the landscape changes, and it changes constantly, and I constantly have to keep going back and looking. So don't think that you already know an answer because I dealt with it like a month ago, because it might be a little bit different now, and that's happened. And so it's okay to spend the extra, you should spend the extra time double checking yourself. I have to do it, and I know you do too, Diane. Yeah, and so there are 3 different places where you can get resources on all of these questions. One is CBIA.com. We have a lot of information on the vaccine and a lot of these questions that we've been talking about today. You can also go to the Connecticut portal at ct.gov.
And Vincent, do you want to give your website address? I know
Yes,
you.
absolutely. We have a coronavirus resource page on there. It's carmodylaw.com, CARMODYLAW.com.
Okay. Thanks very much. Thank you to everyone again for coming to the webinar. We had a really big group and we had lots of really good questions. I hope we were able to help people out there. And if you have questions, like I said, go to those resources that have been mentioned so far. And everybody have a good day. Thanks, Vincent.
Bye. Thanks for having me.